Courtrooms can get quite intense, depending on the case that is, but in some of these cases, it's not always the convicts that wreak havoc, it's the lawyers too. So let's get right into it.
Is there anything you would like to say?
Your Honor, I know I'm innocent. But I guess what I know and what I think really doesn't matter. I just wish the state would have done more in finding out who the actual person was, instead of being satisfied with detaining me and proving my guilt.
That was Nathaniel Roland. He was claiming to be innocent just before the judge had given him his sentence. This is what the judge had to say after he tried to make himself out to be innocent.
The evidence in this case was, I chose the word an avalanche of evidence, and now I've seen it repeated a few times. I've heard it repeated. But the evidence in this case was so overwhelming. The law enforcement in this case did the best job of investigating a case that I have seen over the past 30 or 40 years. There's 1,000 trails. Each trail led to you. All of the evidence, every speck of the evidence, not simply beyond a reasonable doubt, but as high a standard as the law requires, all points to your guilt. And I am absolutely satisfied. I can certainly understand the family being in total disbelief that the child that they raised could do such a heinous thing, could commit such a murder, dealt with the heartless. And you fall into that category, a person without any remorse whatsoever, a person who is totally emotionless, and in the law we call it a depraved heart. And it would be absolutely astonishing, amazing to me for the truth to be that you have engaged in this activity all of a sudden, that there are not signs that your family can point to, that your friends can point to, where if some intervention had taken place, this young lady would have been protected.
So, and I'm going to try to speed up this process so I don't have to wait 15 years, because I got better things to do in my time. The sooner that I get euthanized, as far as I'm concerned, the faster I can get, the sooner I can fetch myself a new body and come back again, a fresh body. That's how I look at it, because that's how it is. That's how it's spiritual work. We're eternal beings. So the way I look at it is, the sooner I euthanize, the sooner I can come back. I've got better things to do with my time than to hang out and spend the next 15, 20 years on death row or in any prison system. So that's what I'm asking for. It's selfish, but that's what I want. So that's all I really have to say.
All right.
Thank you.
That was Stephen Lorenzo. He was in court for murder, and that was him asking the judge to give him a death sentence. Quite a hectic demand, I'd say, but he knows what he deserves for the crimes he has committed. Here is what the judge gave him in return.
Thank you. And I don't know if what you say is perhaps some form of reverse psychology, nor do I care. I will not consider what you want in issuing my sentence.
I know that. Yes.
All right. So I am then ready to proceed. Did you have anything else that you want to say?
No, I'm pretty good. I'm looking forward to getting this over with. It's been 5 long years. Yeah.
All right. Does the state, based on the fact that the defendant made a statement, have anything to say before I announce the sentence in this case? They have been waiting 20 years for justice. Today, that long wait ends. In the words of Miss Pam Williams, from one Italian to another, ti condano a morte. That translates to, I sentence you, Mr. Lorenzo, to death. That is the punishment that you deserve
Thank you.
for these horrific crimes. My reasoning is explained in a 40-page order that I have prepared and signed and am filing contemporaneous with this sentence. Will be handed out to the defense and the state now. You were previously adjudicated. You shall be transferred to the Department of Corrections to await your execution. You have 30 days to appeal this sentence. Mr. Gonzalez, I ask that you file a notice of appeal before you file a motion to withdraw as standby counsel.
Judge, I will inform the court that Mr. Lorenzo has already prepared a notice of appeal, and I intend on filing it when we leave the courtroom.
I appreciate that.
Very good.
Excellent. Thank you all very much.
Thank you, Your Honor. I
And
appreciate it.
Mr. Lorenzo, may God have mercy on your soul.
My soul is fine. Thank you, sir.
Mr. Lorenzo was quite chuffed about his sentence. Never have I ever seen a convict smile after receiving a death sentence. I have a feeling that it's some form of reverse psychology in order for him to have the last say, at least in his mind.
Mr. Jones, you may not say to this jury that you complied with discovery. That is not true. You may not say it again. You may not tell this jury that you are bankrupt. That is also not true. You may have filed for bankruptcy. I don't know that, but I've heard that. That doesn't make a person or a company bankrupt.
That was just the beginning of the interaction between the judge and the defendant, Alex Jones. Listen to how she truly puts him in his place.
You're already under oath to tell the truth. You've already violated that oath twice today in just those two examples. It seems absurd to instruct you again that you must tell the truth while you testify, yet here I am. You must tell the truth while you testify. This is not your show. You need to slow down and not take what you see as opportunities to further the message you're wanting to further. And instead, only answer the specific and exact question you have been asked. No asides. The comments about discovery, the comments about the larynx or whatever it was, the comments about bankruptcy, none of those were responsive to questions. They were just you abusing my tolerance and making asides to the jury improperly and in at least two cases, untruthfully. Do you understand what I have said? Yes or no? Do you understand what I have said?
Yes, I believe what I said was true. So I don't.
Yes, you believe everything you say is true, but it isn't. Your beliefs do not make something true.
This next convict actually has the guts to threaten the judge that is handling his case. Here is how the judge handled him.
Mr. Rhodes, you can just bring him up right here.
Why y'all have me come out like this for?
I think you know why.
What?
You know exactly why. Now, listen, stop talking. Have been.
Oh my God.
Are you done?
No, I ain't done.
You've been charged in the
What I've
fourth
been
degree.
charged with? Why
I'm
you
going to keep
charging me
talking because I don't want to have to see you back here for this.
What you think where you live at? What you think at? None of that. I ain't do
So you're saying you're going to find out where I'm out?
none of that. You got family, I'll be out.
Okay.
Yeah,
You've been
I
charged
don't
with assault in the fourth degree,
I don't
minor
care about none of
injury,
that.
terroristic threatening in the third degree, with physical contact. New charges. I'm entering a plea of not guilty on your behalf. Would you like me to
not
read the
guilty.
arrest warrant to you?
No, I'm not guilty.
I am setting a bond of $15,000 full cash on that on those charges, and the other case, once this actually gets served on you, is going to be dismissed without prejudice as duplicate. Do you have any questions? Would you like appointment of a public
Not
defender?
guilty. Not guilty.
I just said that.
Not guilty.
I
I'll
just
be
said
out.
that.
I'll be out.
Okay, I
Alright.
just said that.
Alright.
And
Take
would
me
you
back
like
to
an
my cell.
attorney?
Take me back to my cell.
I'm not taking you anywhere. They can take you back, but would you like an attorney?
All right.
Okay. I'm going to appoint the public defender's office. Ms. Schwerin, that was a threat against the court. I think that I'm asking the county attorney's office to take that into account and consider what to do with that.
Now we move on to Jacob Oberg. He completely lashed out at a judge during the trial. Fair warning, he uses a lot of profanity.
Mr. Oberg, having been found guilty of rape and of being a persistent violator, it becomes this court's duty to sentence you. We will schedule sentencing for May 24th, 2019 at 9 a.m.
I have an objection to that, Your Honor.
State it through your counsel, please.
No, they are no longer my counsel. I represent myself at this point. I want to be sentenced now.
I cannot sentence you now.
Yes, you can, Your Honor.
Mr. Oberg, before I can sentence you, this court has an obligation to obtain a pre-sentence investigation. Okay, Mr.
No.
Oberg,
I want to be sentenced now.
you're not going to be sentenced now.
You can go yourself then.
And I'm going to hold you in contempt if you keep it up, or I'm just going to remove you.
What are you going to do about it, mother?
All right. You're helping yourself a lot, Mr. Oberg.
I don't give a flying. What are you going to do about it? Sentence me to prison? Wow, I'm already going for 20 years. That's a persistent violator right there, mother.
Your sentencing will be set for May 24th at 9 a.m.
No,
I'm ordering
no,
a pre-sentence investigation.
I ain't coming.
Go ahead. Well, we'll see.
Yeah.
Go ahead and remove him from the courtroom.
He can testify truthfully without violating the court's order and putting himself in contempt.
Or I don't know.
Or I don't know.
All right, so
The
how
problem
does,
with that, Judge, is it's argumentative in tone. He's not an expert, and so what one does isn't what we're
But
here to
that's-
show.
but-
We're here to show what he did.
right, but
And the
that's a
purpose
different,
is being
no,
offered to
Attorney
get into the
Pattis,
state of
Attorney
mind.
Pattis, Attorney Pattis, how many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. So, your objection was that
As if Alex Jones was not enough for this judge to handle, his lawyer was a nuisance too. This is how Norm thinks the way of law goes in court. Apparently interrupting the judge is a hobby of his.
So, can I just see counsel in the meantime? So I can count on one hand how many times I've argued when you've done my entire career. I've seen you argue and you stop on a dime. You gotta do that for me. You have a good record. You have your objections.
You're right.
I'm right.
You're right.
That's in there. That's a positive
no,
note.
Look, Judge, here's the deal. I'm an advocate. I get lost in the moment. You've admonished me, and I'm working on it.
You're standing up for your objections, though. Right?
I'm a member of Advocates Anonymous, Judge. If I warm too much to my client's cause, that's why courts are here to assure fair trials.
We're good.
This next guy is a lawyer, but he seems to be acting very much like a Karen. Listen to how he's speaking to the judge. Obviously, the judge was having none of it.
What's the nature of your objection, Mr. Shellhorn?
Judge, I think there was a question there suggesting that the attack, the dog bite, and I think there was something else was going on before any shots were fired. I'm
Yeah,
not sure
I don't even know what
Exactly.
the, I don't even know what the factual basis is for that.
Judge, I can ask a witness.
No, you
whether-
can't. No, you can't. Not without a factual basis. You just can't ask for speculation. That's what you're asking for.
I'm asking you a question whether or not,
There's no evidence that it happened before. None.
Judge.
Not a scintilla
I believe.
of evidence on the record so far
So
that
if
that
a wit-
supports that question.
If a witness says that something happened, I can't ask them if.
You've asked them 500 questions about what happened, about her recollection of it, which is fine. Now you're asking, well, are you sure it didn't happen before? You have no basis to ask that.
Her recollection is horrible.
No, it's not.
She's changed her story over and over.
It doesn't matter.
again.
It doesn't,
It's in-
Mr. Belinkus, it does not allow you to suggest to this jury to engage in speculation, which is what you're doing. Your client doesn't remember the incident. according to the expert reports. So that's not a factual basis for you. If the scenario changes, then you can ask it then. At this point in time, there's nothing in the record to suggest the scenario that you want to ask in a question for the jurors. There's not.
Judge, okay.
That's my ruling. End of it. All right. Go off the record now because you have to